and hostility will continue to harm them and their children. Thus, lawmakers must explore ways to help parents forgive their former spouse. In other words, family law must cultivate forgiveness. Solangel?
Thank you. So thank you so much for inviting me. I'm flattered to be on part of this symposium with very distinguished speakers. As you heard, I'm a lawyer. I'm a law professor. So what I do is I take the work of philosophers, psychologists, and other theorists, and I try to apply it to problems in the law, to legal problems. And my focus currently is really looking at how forgiveness can help us solve some problems in family law. So I'm going to start with a rather obvious statement. Many divorced parents are angry. Many are vengeful. Now, we heard from Professor Exline that anger is not necessarily a bad thing. Anger can actually be very good. But we know from years of research that prolonged interparental anger and hostility is actually very harmful to children, increasing the risk of depression, anxiety, low self-esteem, and behavioral problems in children. And so that is why I argue that the law has to help divorced parents learn how to forgive each other so that they can decrease their anger and hostility and thereby be able to better parent their children. So my remarks are organized into three parts. First, I'm going to briefly discuss the evidence demonstrating that interparental anger and hostility are detrimental both to parents and their children. Then I will describe lawmakers' efforts to reduce anger and conflict between divorcing parents and explain why such efforts have had limited success at best. Finally, I'll discuss several forgiveness models and developed by psychologists, philosophers, etc., and propose that courts should require high-conflict, angry parents to participate in a forgiveness education program. I refer to these programs as healing divorce, and I believe that such a program could help parents reduce their anger and hostility towards the other parent. Now, psychologists agree that the decision to divorce is extremely hard, even when the decision to end the marriage is mutual. As I said, one or both spouses may feel angry, vengeful, betrayed, rejected, hopeless, and this leads people to behave badly. Angry spouses hurt each other in any way they can. Some destroy valuable property, including homes, pets. They disparage the estranged spouse to anyone who will listen. And for those of us in teaching, we're familiar with every casebook has numerous stories of angry spouses who engage in vengeful behavior. And every matrimonial attorney and therapist has dozens of stories about the lens through which divorced spouses will sort of resort to exact revenge on the other spouse, oftentimes using children as pawns in their battles, unwittingly, but just as harmful. So how exactly does interparental anger harm parents? Well, lots of ways. Studies have found, as Professor Exline mentioned, a correlation between long-term, prolonged anger and high blood pressure, poor cardiovascular health, depression, anxiety, and low self-esteem. There's also some evidence that high-conflict parents are at increased risk for severe psychopathologies and substance abuse problems. But I'm more concerned about the harm on children, because that's really my focus. Interparental anger has many detrimental effects on children. Angry parents sometimes refuse to reach a parenting time agreement, some sort of custodial and visitation agreement. They denigrate the other parent to the children. They interfere with visitation, place unrealistic restrictions on visitation, may withhold child support, and in some rare cases, but it still happens, may falsely allege allegations of child abuse against the other parent. Angry spouses also have been known known to launch custody fights out of dispute, out of spite. And Professor Bob Emery at the University of Virginia has actually done a lot of work in this area. Now, according to some estimates, as many as 1/3 of divorced parents, divorced families are characterized as high conflict or intensely hostile. Now, given that half of the 1 million or so children who experience their parents' divorce each year are under the age of 6, we could see that a significant number of children of divorce whose parents have this very angry, hostile, high conflict relationship will be exposed to this conflict for a large part of their childhood. And when parents are angry, they take it out on their children, or they actually harm their children in a number of ways. For example, they can't agree about minor issues such as who's going to get the child on Friday, and they come back to court to try to resolve these issues. Can the child have telephone access with the parent on a Wednesday at 3 p.m., who's going to get the child for this holiday on this particular year, et cetera, et cetera, et cetera. And every time the parents go back to court to attempt to resolve these disputes, it only leads to the escalation of the hostility, the escalation of the anger. Now, in a perfect world, parents would encourage their children to love and respect both parents, and would never ask or expect their children to choose between them. Unfortunately, some angry parents do make children feel guilty for loving or wanting to spend time with the other children. They want their children to take sides. And when children are angry, when parents are angry towards each other, children know it. They sense it. But they're often privy to their parents' disputes. So they will hear their parents discussing child support, arguing about the child's extracurricular activities, arguing about visitation, et cetera, et cetera. A child in any one of these situations is at higher risk for a myriad of emotional, behavioral, and psychological problems. Studies have shown that interparental conflict and hostility are the primary determinants of children's poor adjustment to divorce, thereby placing them at higher risk for behavioral problems, depression, anxiety, and low self-esteem. Children of angry parents are also more likely to be subjected to poor parenting. Not surprisingly, studies have found that positive parenting skills, such as responsiveness and understanding of their children's needs, tend to decrease when interparental conflict is high, while bad parenting practices, such as yelling and harshness of tone to the children and lack of patience, tend to increase when parents are angry. Parents may also displace their anger towards the other parent onto their children. So a parent who's angry may say, "You remind me of your father right now, so get out of my face." Interparental anger also harms children in another way, by increasing the likelihood, the risk that the non-residential parent, usually the father, will abandon the child both emotionally and financially. In recent years, social scientists and legal scholars have explored the reasons why as many as 30% of non-custodial fathers have little or no contact with their children within 1 year after the divorce. And by little contact, we mean not having any contact in 12 months or longer. Although the reasons for paternal disengagement are many and complex, studies have found that the non-residential father's relationship with the custodial mother may be the stronger determinant of paternal disengagement. Now, this is not surprising. When two parents have a hostile relationship, fathers are more likely to disengage because, whether correctly or incorrectly, they fear that the custodial mother is alienating the children from him, that the mother may interfere with visitation, may disparage the parent to the children. And even when this isn't happening, when parents have a hostile relationship, it makes interaction between the parents very difficult, which is likely to contribute to paternal disengagement. Parents don't want to deal with another angry parent, so it makes it a little bit easier to simply disengage. So lawmakers are very much aware of this. Lawmakers are very aware that parental anger and hostility is very harmful to children. So what have lawmakers done in the last 20 years to try to reduce interparental anger after divorce? I'm going to focus on three things. First, no-fault divorce. Second, mediation. And third, parenting education. For most of American history, the only way for parties to get a divorce, to end the marriage, was to show that the other party had committed fault, meaning adultery, extreme cruelty, abandonment. Many critics of this fault-based system argued that the requirement of fault actually raised the level of intensity, bitterness, and acrimony of divorce proceedings, and critics of the no-fault divorce system, no-fault reformers, sought to replace this adversarial model of divorce with one that would actually remove the weapons of blame and retaliation from embittered spouses. So when California legislators passed the first no-fault divorce statute in the U.S. in 1969, allowing spouses to end their marriage on the grounds of irreconcilable differences, they envisioned a system, as Professor Hermer Hill Kay, who's one of the drafters of the statute, said, they envisioned a system that would enable the parties to end their marriage as amicably as possible. That has not happened. For a variety of reasons. One reason is that although every single state now has no-fault divorce, 2/3 of the state have simply added no-fault divorce to their fault-based system. So in many states, fault continues to matter. But interestingly, even in those states that are pure no-fault states, the ability, the eradication of fault-based divorce has not actually made the divorce process amicable. It did not end the bitterness of divorce. And as some family law scholars have actually noted, it was naive to expect that simply by removing fault from divorce, that would eliminate the animosity that had actually characterized proceedings under the fault-based system. And I am often reminded of Professor Marigold Melly at the University of Wisconsin, who provides a story of being asked to testify in support of a no-fault divorce bill in Wisconsin. And the senator said, if you support this bill, it will remove all of the hostility and bitterness that we see in divorce now. And she said, and this is a quote, "Senator, if my husband of 20 years decides he prefers a new, probably younger wife to me, I want you to know that I will be just as spiteful and bitter and uncooperative as I can." And she stands by that. And she was right. In cases where only one party wants to exit the marriage, the legal irrelevance of fault has not really made the process any less bitter. And to the contrary, there's some evidence that has actually made the process even more bitter, because now that they're in those states where the only way to obtain a divorce is through no-fault divorce, there's no mechanism for an angry spouse to express his anger, his indignation, and to obtain vindication. So not surprisingly, angry spouses found other ways to bring fault and blame into the divorce. They've brought it into child custody and visitation proceedings. So since no-fault divorce did little to reduce divorcing spouses' anger and hostility, lawmakers, along with mental health experts, continue to explore other ways to reduce the financial and emotional costs of of bitter divorces. So this is where mediation, family mediation, mediation of custody and visitation disputes came in, and as a result, a significant number of states actually require parties to mediate custody and visitation disputes. Now, mediation has many advantages over litigation. I think the center, is very much is a clear sort of example of how mediation can be an improvement over the adversarial adversarial process. Studies show that mediation clients are more satisfied with the divorce outcomes. Parties who negotiate custody and visitation agreements are more likely to comply with them, and non-residential fathers who mediate custody and visitation tend to have higher rates of paternal involvement than parents who went through the adversarial process. However, despite these benefits, mediation has not achieved one of its stated goals. quote, to reduce any acrimony that exists between the parties to a dispute involving divorce or involving custody or visitation. I'm reading that language from the North Carolina mediation statute, but this is language in many mediation statutes throughout the country. Mediation of custody and visitation disputes was supposed to reduce acrimony between the parties, but it really has not done so. Even though some studies have found that mediation did reduce interparental conflict and hostility among parents who were divorcing, those studies focused on voluntary mediation between parents who were paying for the process themselves, who were going through as many sessions as necessary, and who tended to be more cooperative, better educated, and of higher socioeconomic status than couples who are generally participating in court-ordered mediation. Court-ordered mediation in many states is usually limited to 1 to 2 sessions, what I call basically assembly line mediations. And although a therapeutic model of mediation, one which allows the parties to express their feelings and incorporate counseling into the process, may work, may help reduce anger and parental conflict. The reality is that most mediators in court-sponsored programs are not able to use this model of mediation. In addition, the focus in court-sponsored mediation programs, the focus has been on getting parents to reach an agreement. And that focus on reaching an agreement may actually be inconsistent or limit the mediator's ability to help parents reduce the anger, which may actually require that they express it. And one of the things that we heard this morning is that before we can get to forgiveness, it's important for parties to express the anger rather than trying to sort of sweep it under the rug. In addition to no-fault divorce and mediation, many states have also created mandatory parenting education programs, and we don't really have any empirical evidence that these programs are actually helping to reduce interparental anger and hostility. One study found that although most parents think that these programs are a good idea, and after they leave the program, after 3 hours of parenting education, they're very satisfied. 6 months, a year later, nothing has really changed. Okay, so now that we've seen sort of 3 different reforms that have not been as successful as we would want them to be, what can reduce interparental anger? Well, not surprisingly, I believe that forgiveness can. So before we discuss forgiveness's potential, of course, we need to figure out sort of our definition of forgiveness. And we saw a number of definitions this morning. So I just want to sort of mention a few. And remember, none of these are my own. These are definitions of philosophers and psychologists, but we'll find something to work with. According to psychologist Robert Enright at the University of Wisconsin, forgiveness is the willingness to abandon one's right to resentment, negative judgment, and indifferent behavior toward one who unjustly injured us, while fostering the undeserved qualities of compassion, generosity, and even love towards the injurer. The philosopher Joanna North has stated that forgiveness is a matter of a willed change of heart, the successful result of an active endeavor to change bad thoughts with good thoughts, to replace bitterness and anger with compassion and affection. And finally, Fred Luskin, the co-founder of the Stanford University Forgiveness Project, defines forgiveness as the peace and understanding that occurs when an injured party's suffering is reduced as they transform their grievance against an offending party. Now, what all of these definitions have in common, and what's important, I think, to my focus, is that they all acknowledge the reduction of anger as the element, the crucial element of sort of forgiveness. And as we said, just to remind us of what we talked about this morning, we know that forgiveness, at least most scholars agree, is about reducing anger. But of course, there may be other requirements as well. But we all remember that forgiveness is not the same as condemnation, not the same as excusing the offender's behavior, and not about forgetting the hurt that was inflicted. Also, forgiveness is not the same as reconciliation. This is very important for, I think, the rest of my talk. So to give an example, in order for a bad battered woman to forgive her abusive spouse, she must let go of her anger, her hatred, and her desire for revenge. However, that does not mean that she needs to have contact or reconcile with her abuser ever again. She can forgive. Under the definition that I'm adopting, she can forgive and end the relationship. She also does not need to give up her desire for justice. So punishment and restitution may actually be appropriate, even though she has forgiven her abuser. Finally, because forgiveness is separate from reconciliation, I believe that a person may choose to forgive regardless of the other person's current attitude and behavior towards him or her. And I think this is very important in the context of divorce. To illustrate, a woman whose ex-husband was unfaithful, verbally abusive, and continues to disparage her in front of the children can choose to forgive her former husband despite his failure to apologize, despite his showing of remorse or any type of indication that his behavior is going to change. Now, you might wonder why she should attempt to forgive someone who is not about to change his behavior, especially when we've heard that it's not a bad thing to be angry. Well, the answer is simple. Because forgiveness may actually help her heal psychologically and may help her have a better relationship with her former spouse. But more importantly, it may help her become a better parent to her children. So we saw that forgiveness, we've talked about how forgiveness has the potential to reduce interparental anger, and we saw how the anger and the desire to punish the other parent does lead parents to unwittingly harm their children, to engage in these custody and visitation disputes, to withhold child support, to interfere with visitation. Forgiveness might reduce or eliminate these behaviors. Finally, there is another reason to encourage or to facilitate forgiveness. Although forgiveness and reconciliation are not the same, forgiveness may enable reconciliation in those cases where it is desirable. While many divorcing spouses would prefer not to have any contact ever again, that is not a choice for many parents who share minor children in common. They may be forced to deal with each other for a very long time, so it would be in their interest to be able to establish some sort of cooperative parenting relationship. So forgiveness may actually facilitate reconciliation. Now, although many people understand the benefits of forgiveness, in the abstract, they may not actually know how to forgive. And this is why I think the work that some psychologists have done on forgiveness education and forgiveness interventions is so important. So I just want to briefly discuss two different models of forgiveness, not because I'm endorsing them, but to give an idea of what the law should consider if we were to try to create some sort of forgiveness education programs. So first, Robert N. Reich has developed this process model of forgiveness, which basically consists of these four phases, where in the first phase, the injured person acknowledges the pain, the hurt that another person has caused him, and actually reacts with anger, embraces that anger in order to be able to move on. In the second phase, the person realizes that holding on to this anger is really not helping him or her in any way, and that the anger has actually sort of taken over his life. And this is, I'm reminded of Professor Exline's spin cycle analogy of the anger just sort of, keeps going on and on in your head, and it's taking over your ability to sort of go about your everyday life. So at that point, the person may decide to actually forgive. Now, this is an intellectual decision. I'm committing to forgiving. It does not mean that the person is actually forgiven yet. Emotional forgiveness is a process, and it may take a long time. And finally, as we heard earlier, the injured party at some point may start sort of reframing, re-envisioning the injurer as a human being, starts to see this person as, well, maybe I could have done the same things. I could understand his behavior, although I'm not condoning it. So, for example, a battered woman may learn that the batterer had been abused as a child himself. This is not excusing or condoning his behavior, but now she understands, can actually sort of understand his behavior a little bit better, and this might enable her to forgive, even though she is not condoning or excusing the behavior. Now, psychologist Everett Worthington, as Professor Exline mentioned, also has come up with a model of forgiveness, and this model focuses on empathy, humility, and a commitment to forgiving. And based on this pyramid model, Worthington has developed this 5-step forgiveness intervention, which has been applied in marriage counseling, and it requires the party to recall the hurt, so very similar to the process model, to recall instances where he or she actually needed someone's forgiveness herself. The goal is to foster empathy and humility, which will enable the offended party to actually sort of forgive, to give this gift of forgiveness. And the 4th and 5th steps require that the person verbally commit to forgiving and find ways to hold on to forgiveness, even though their anger will come back periodically. But if they are committed to forgiving, they'll remind themselves that I am committing myself to this process and will continue to sort of hold on to forgiveness. Now, many published studies have actually used these models to help participants forgive offenses such as neglect, marital infidelity, parental love deprivation, and even incest. And so some of these sessions involve sort of 8 or 9, 60-minute group sessions. And what they found is that the participants in these sessions after these 8 weeks had fewer negative feelings towards the person who had actually hurt them than the control group. And they reported, this was all self-reported, of course, a greater willingness to forgive. One unpublished study is particularly sort of relevant for my discussion. It looked at forgiveness and divorce. Can group interventions facilitate forgiveness of a former spouse? And here, the researchers randomly assigned 149 individuals to a secular forgiveness group, another group to a religious integrated forgiveness group, and then another group to a waitlist control group. What they found is that there were no differences between the secular forgiveness group and the religiously integrated forgiveness group. No difference between those two, but there were clear differences between those two forgiveness groups and the waitlist control group. So participants in the forgiveness groups reported higher levels of forgiveness and lower depression and lower anger than the waitlist control groups. Now, what I believe is that these studies suggest that forgiveness can be successfully taught or facilitated. I don't presume to know how a forgiveness program, how a healing divorce program for divorcing parents should be structured. So rather than adopting a particular model, I think that lawmakers have to experiment with a number of different approaches and variations. But that being said, I think there are a number of considerations that are worth exploring at the outset. First, as forgiveness scholars have argued, many individuals do not know how to forgive. And given that that angry parents, that divorcing parents are oftentimes angry and could potentially benefit from forgiving their former spouses, one would think that participation in forgiveness education should be mandatory in the same way that parenting education is mandatory in many states for all divorcing parents. However, due to limited resources, I would propose that lawmakers experiment first with the high conflict parents, the ones that are more likely to cause harm to children because of their long-term hostility. Second, although few published studies have actually attempted group forgiveness interventions with the injurer and the injured party in the same group, therapists specializing in marriage and family counseling have successfully used these forgiveness models with couples. So, for example, Richard Fitzgibbons, an experienced psychiatrist and author of a seminal article on the use of forgiveness in the treatment of anger, has actually found that the willingness of the offender to participate in the work phase of the process model has actually been very helpful in the resolution of the injured person's anger. And the reason, as we heard from Professor Smith, is that when the injurer apologizes, assuming that it's a very genuine apology, this may actually facilitate forgiveness. Of course, there are many risks that we can all think about, that we can sort of imagine when the injurer and the injured party are actually in the same room together, in the same sort of forgiveness intervention. So lawmakers would have to sort of explore what type of intervention might be less disruptive and most beneficial. So those are just a few of the challenges raised by forgiveness interventions for divorcing parents. And finally, I want to point out that I don't believe that most parents who participate in forgiveness interventions will, after 8 weeks, miraculously forgive the other parent. However, I believe that they would reap some benefits of forgiveness. There might be some reduction in anger, and quite importantly, the commitment to working on forgiveness, to letting go of the anger, and to letting go of sort of the desire for revenge. But as we saw, forgiveness is a process, and so the fact that people now know what forgiveness is and what the benefits are for them and for their children, it provides a huge incentive for parents to work on forgiving each other. I would like to talk about sort of potential objections to my proposal and sort of link it to some of the work on the TRC. But in the interest of time, I think what I'll do is I'll stop now, and we can talk about these issues during the Q&A if people are interested. Thank you.
Thank you. Next, we have Susan, who, in her work on the comprehensive law movement, has written, "The converging main vectors of the movement towards law as a healing profession coalesce into two common features, thus unifying the vectors as a movement. First, each explicitly recognizes and values law's potential as an agent of positive interpersonal and individual change, and seeks to bring about a positive result such as healing, wholeness, harmony, or optimal human functioning as a part of the resolution of legal matters. Second, each integrates and values extra legal concerns, factors beyond strict legal rights and duties, into the law and legal practice. These rights plus factors include needs, resources, goals, moral values, beliefs, psychological matters, personal well-being, human development and growth, interpersonal relations, and community well-being. Law as a healing profession has great transformational potential. It could begin to address the tripartite crisis in the legal profession of deprofessionalism, low public opinion of lawyers, and lawyer distress. It could make the legal system a more inspiring, humane, and hospitable place for clients, lawyers, judges, and indeed society as a whole." Susan?
Thanks, Kathy. Can I tell them how you and I met? Kathy and I started, well, she was before me a little bit. We started teaching at the same law school together, so we got to start our careers as law professors together. At least that's the way I feel. Anyway, those are very brave words, that stuff I wrote. Listening to that, I thought, wow, okay. So, let's see. All right, I'm a law professor. I was a corporate securities and tax lawyer before I became a law professor. I stopped that for a while and got a master's degree in clinical psychology and worked as a mental health therapist, primarily with adult survivors of trauma. And then went back into the practice of law and then became a law professor. So currently I teach contracts. So some of what I had to do this morning is review some modifications to contracts that my students are drafting and send comments back to them by PDF so that they can have their information because their stuff's due by midnight tonight. So that's kind of fun. But I'm really here, I think. I teach a class that I developed called Law. It's called Comprehensive Law Practice. And it really tries to teach law as a healing profession, and it really tries to integrate social science into law the way Professor Maldonado has given us a great example of. So I think I'm here to talk about that and to talk about to give you some frameworks, because really what I've been hearing, and I've really enjoyed everything I've heard. The social science part of me has loved the morning, and then the legal part of me has enjoyed all the rest of it. But I really think that for me, I'm the kind of person who needs a framework. I need to understand how it all fits in. So let's see if I make this work right. Oh, that's hard to see, isn't it? Okay. Well, some of it's hard to see. So I've been interested since about 1990. There's been a series of emerging developments in the law that I began to be involved in because of my law and psychology interests, and some of them, the main one was therapeutic jurisprudence. But at one of these therapeutic jurisprudence conferences, I met some people in restorative justice. How many people have heard of restorative justice in the criminal law field? Okay, all right, fantastic. How about therapeutic jurisprudence? Yeah, a couple. Okay, good. All right. How about drug treatment courts? Yeah, all right, better. All right. So drug treatment courts are an example of problem-solving courts. Then there's these other sort of what I call vectors of this movement. And it just seemed to me that there was about 10 or so vectors and that they were all kind of going to the same place. I said, we are, how about transformative mediation since we're among mediators? All right, fantastic. All right, about half. Okay, great. So, and collaborative law is another one of these, and yeah, in the divorce area. So I was interested in this movement. And what Kathy read was sort of this slide, is that one of my mentors said, Professor Winnick, who's one of the founders of therapeutic jurisprudence, along with David Wexler, said, well, Susan, if you think it's a movement, then why don't you explain where it coalesces? Why do you think these things are really related? I really think they're different. They're different disciplines. I said, well, they're different, but they have that family resemblance. And so, sorry, I don't know why. It's been in there a long time. I can't get it back out. I kind of like it because it's funny. It's sort of like, yay! But they all seek to optimize human well-being. Now, if you went to law school, how many folks went to law school? Okay. When you went to law school, did they say, we're here to help people be better people? No, that was not the plan. Although for me, being sort of a social science person, undercover social scientist, I thought maybe I could make a difference, make things better. Maybe people come to law school because they want to make a difference, they want to make things better. But these vectors explicitly say that if we can optimize human well-being without trampling legal rights, without denigrating in any way legal rights, if we have two ways to practice or adjudicate law, and one way helps people feel better, function better, be happier after the divorce, whatever it is, and one way doesn't, and both are exactly equal in terms of legal rights, why don't we just optimize human well-being? Why don't we do it? We could. And some people call the human well-being harmony, between people, reconciliation we've talked about. Some people call it moral growth. Transformative mediation calls it that. Therapeutic jurisprudence calls it healing and says we can, started in mental health law, but has expanded to a lot of other areas and says we can practice law and adjudicate law and manage legal processes in a way that can actually be, I hate this word, but it's the only one it's the only one that really captures it, sanative, helpful, ameliorative, make people better, feel better. And then the other thing that all these vectors do is they all focus on more than just simple bare legal rights. So where we came to law school and they said, forget all that stuff you think about before you came to law school, just the facts, just the legal rights, analyze, where's your legal analysis? It now says, well, guess what? People's needs are important, and their goals and their beliefs and their morals and their resources and their relationships and where they come from and their community and their psychological state of mind, all that is important in making decisions and helping people make decisions about how they want to go through a legal process. So there's some societal shifts, I think, that, that tell us why some of this stuff is happening now. And I think we've talked about some of that this morning. We've talked about, I think, are no longer see ourselves as individuals. We see ourselves as connected now. The world has gotten a lot smaller. The Cold War ended with all that hostility, the sort of them and us mentality that I sort of grew up with. We've overused litigation in our society to resolve legal disputes, and we're turning to other ways to resolve those disputes by looking at the interpersonal failure that might underpin the dispute. Corporate leadership has focused on humility and transparency. We talked about this morning about people, apologizing and coming forward and being open about what they've done. I think we've also become aware that different truths are true for different people, and that the truth may not always be something we can find. So I kind of created this. Actually, Professor Wexler is the one who kind of came up with this idea. He said some of your vectors are like lenses through which you look at a particular legal matter, and some are processes. So we could take a therapeutic jurisprudence view towards traditional litigation, traditional settlement, or even ADR, and say, how can I make traditional litigation more therapeutic for my clients? But happily, some other vectors have come along, like problem-solving courts, transformative mediation, collaborative law, and divorce. I have these little monikers for them, so I apologize for the little acronyms. But restorative justice is one of the ones that I think is particularly relevant to our topics today in terms of apology, forgiveness, reconciliation. So some of these function almost like a lens. How do I look at the legal matter? I could look at it traditionally and say, I'm just here to win, just here to get my client what they want, most money they possibly can get, or least amount of criminal sentence possible. But I could look at the client and say, what's best for them overall, comprehensively as a person? What's best for their relationships? And then I have a whole new set of tools as a lawyer to pick from to figure out how to help them through their legal matter. So, whereas our traditional lens sends us right to litigation, right? You can hardly read it. The traditional win-lose, the binary lens sends us right to litigation. Now, through this movement, we have all these other ways to look at what we're doing. And so the value of, or the importance of apology, forgiveness, and reconciliation fit within this framework in that we now have a way to say, oh, this makes perfect sense, because if my lens is as a therapeutic lawyer or even a preventive lawyer, and I want to prevent recidivism in a criminal or even a civil client, then this makes sense, because if apology, forgiveness, and or not reconciliation, let's just say maybe apology, if we know that prevents recidivism, which the empirical data says that it does, and forgiveness, if that core sequence together prevents recidivism, then we can be preventive, and we have a reason to do that. We can say, we have a legitimate way to say, these are things I need to talk to my clients about, I need to consider bringing into the legal process. So Therapeutic Jurisprudence has a fantastic website. If you are doing any writing, it has a fantastic bibliography. But here's a nice definition from Chris Logan, who's been one of the critics, I guess, of therapeutic jurisprudence. But it is using social science to study the extent to which a legal rule or practice, and here we would also add or process, promotes the psychological or physical well-being of the people it affects. This may have been mainly theoretical and has used these other sort of approaches as some of its tools and in its toolkit. Been used extensively. Okay. So therapeutic jurisprudence does exactly what Professor Maldonado has done in her paper, which is to look at social science and say, let me look at the social science enough to get a flavor for it. I'm not going to become a social scientist, I'm a lawyer or a judge. But let me look at the social science and ask, how does this inform what I do? Is there a way that I might think about how I'm at least not practice law or adjudicate law in a way that makes people worse? Because I think a lot of times litigation may have done some of that. So I want to talk about, there's a picture of, these are just some different pictures of collaborative law. I want to talk, though, about some of the social science wisdom that I want to apply, and then see how this applies to law and see how we can fit it all together in terms of apology and forgiveness and reconciliation. So I've sort of explained a little bit about therapeutic jurisprudence. There's other vectors I'm going to leave off to the side just for a second. But I want to look at some social science wisdom, I think, that relates to what we're talking about. We talked about anger at length, I guess, already. We've talked about the effects of anger. And some of the, Professor Maldonado had talked about the deleterious effects of anger post-divorce. I would say that all criminal and civil litigants may experience some post-litigation anger. I would expand that and say that there's probably a lot of anger going on. And that if we look at the grief process, remember the Elizabeth Kubler-Ross's The 5 Stages of Grief: denial, anger, bargaining, depression, acceptance? From undergraduate psychology, I remember this. It seems that I would argue that all criminal offenses involve a loss, which would trigger the grief process. I don't know, you can tell me if you think this is correct. And that all civil cases probably also involve a loss. So that people are both, perhaps the plaintiff and the defendant, are feeling somewhat of a loss, and they're probably going through the grief process. And so that we as lawyers might be just aware of that and say, well, to what extent do our clients come to us in a particular stage of that process, perhaps anger, because they're frustrated and they want to sue, and somebody's going to pay, and do you have a claim? Somebody may be to pay for your loss. To what extent do we prolong that stage, or to what extent do we facilitate people through the stages and let them go naturally through their stages towards resolution? Because the end of that process is a resolution of that particular grief or loss. Procedural justice is one of the social science disciplines that therapeutic jurisprudence picked up when it began to look at the law and legal processes and what people really wanted. And so this kind of is a framework, I guess, or another word, label, for some of the things we've been talking about today. One of the things that procedural justice says, I don't know how many people are familiar with that. No? Okay. One of the things that procedural justice says is it's some empirical research about litigant satisfaction in legal processes, and it found out that there's 3 things that people really care about when they're going through litigation. And regardless of the outcome, whether or not the outcome was in their favor, these 3 things predicted their satisfaction better than whether they won or lost, which I think to me is just amazing. And there's another little interesting piece of empirical research too. Lawyers tend to focus on the outcome. We tend to focus particularly on the economic outcome. We as a group, this is something I've studied sort of as a side before I started this stuff, we as a group focus on the economic bottom line. We are a show me the money kind of people, you know. So we say, well, did you win or lose? That's what's important. Non-lawyers tend to be really swayed by these things. They want to be able to have voice and participation in a process. They want to be able to tell their story. They want to feel like if they're not sharing decision-making power, they want to feel like that they were treated with dignity by the authorities who were making decisions about them. And if the authorities make a decision and they're not part of that, they at least want the authorities to explain the decision, allow them to speak, and treat them with dignity and respect. That those things are procedural justice pillars that people want. And the social science shows that. But as lawyers, we don't often give them that opportunity. So apology and forgiveness, focusing on those, are chances, or we can consider how they're chances for people to have a voice, for both people to have a voice and to have some decision-making power. Restorative justice is, in the criminal law area, is really an entirely different paradigm for dealing with criminal offenses. And it views crime as violations of people between relationships, not as a violation against the state. It looks at involving the victims, the offender, and the community together in an effort to put things right, as opposed to focusing just on the offender to punish them and to determine culpability and impose punishment. And the focus is on victims' needs and offenders' responsibility. So it's a broader kind of an approach. Restorative justice is kind of where I started when I started preparing to talk to you about apology and forgiveness, because restorative justice has fantastic research on this and really talks a lot about how the process works in terms of I've gone to that. Okay. In terms of criminal law, but I think it's also applicable perhaps also to civil law. So some of the social science I found in looking at the restorative justice ideas about apology and forgiveness talks about the difference between guilt and shame. And some people know this as the difference between guilt and shame. Some social scientists talk about it that way. Some people talk about it as the difference between healthy shame and unhealthy shame. So there's a lot of different labels for this same concept. But the basic concept is that guilt is when someone says, I accept responsibility and I'm willing to change. So guilt or healthy shame is when someone feels badly about what they did, what we've been talking about, when an offender takes responsibility and says, I know what I did, I accept what I did, and I feel badly about it. But I don't feel like a horrible person. I feel like I have the ability to change and be different. Unhealthy shame is when the person feels like they themselves are wrong and they feel uncomfortable. And Thomas Sheff explains that this kind of shame is linked to recidivism, alienation, and a non-integration in society. So what he talks about is through restorative justice and through this core sequence of apology and forgiveness, he says that this unhealthy shame can be turned into what he calls reintegrative shame, or the healthy kind of shame, or what some people call guilt, so that a person can go from, and if you can imagine somebody coming into a victim offender mediation or some kind of a mediative process, and you imagine the offender coming in and kind of being like this, just having their head down and not feeling a part of, not feeling like a human, not feeling like everybody is there, to participate with them, just feeling like I'm just going to be here, they're going to beat up on me, and I'm not into this, I just can't wait till this is over, and then I'm out of here to go be with my friends and do whatever I please, kind of thing. If you can imagine maybe a juvenile offender. That's the unhealthy shame. And there's a shift that occurs when the person sort of looks up, makes eye contact with the victim, and says, I did what I did, and I feel terrible about it. Maybe tears are coming down their face. That's that healthy shame, when they feel that bad feeling, but it's a bad feeling that's going to lead to behavioral change. And so that's the kind of shift they're talking about. Transformative mediation is a civil vector. And then the reason I bring this up is because we've talked also today about standing in somebody else's shoes and seeing something from somebody else's perspective. And social scientists would call that empathy sometimes, of being able to, if I can stand in your shoes and see how, if I'm the offender, I can see how my actions hurt you. I can see how my actions impacted you. I can see how you feel the way you feel about me now because I can stand in your shoes. We would call that empathy. Transformative mediation in a civil context would call that recognition. And they say that it is core and it is extremely foundational, that you can't, transformative mediation would say you can't resolve a civil dispute until the parties have been able to stand in each other's shoes and say to the other one, I can see the dispute now from your perspective. I can understand why you feel the way you feel. And they can express that to each other. There's something interesting or magic that happens. And I imagine most of you that have mediated have probably seen that to be the case. So those are kind of all of the sort of threads of social science wisdom that come in before I get to apology, forgiveness, and reconciliation. So how much time do I have left? 5? Okay, golly, shoot. Okay, so, all right, well then I won't I won't go over all of them. Well then let me tell you a little bit about my bite analogy. My bite analogy is, I've been thinking about this, is that an offense is like a bite comes out of both the victim and the offender, whether this is civil or criminal. And that what we're doing with apology and forgiveness is we're not restoring the bite. We're not going to find the rest of the peanut butter and jelly sandwich and put it back in there. It's all going to be whole again. It's all going to be great. But we're going to do something that is going to restore part of that. It's going to be a replacement. It's going to substitute. But it's not going to be exactly the same. So this core sequence, and this is sort of the framework I think is really helpful. That's why I've made this big slide about it. Thomas Sheff explained this, and he's a social scientist, but I really liked it. And he talked about it in the context of restorative justice, and he says reintegrative shame comes when these things happen. So I think that if we're looking at what's a really successful process, this is what we want to see happen. We want to see the victim express the impact of the offense upon the victim and his or her life. The offender acknowledges the impact and experiences that reintegrative shame. The offender apologizes, the victim offends, forgives the offender, then the offender makes material reparations, and the offender is reintegrated into society. That is what he would say would be a complete success. So all these different things we've talked about all morning and at lunch about what do you need? Do you need this or that, the other thing? For me, this works really well, because if I have all of that, and it's sincere and it's accepted and it really hits home, then I think it's going to be good. So I did a little experiment in my class, in my comprehensive law practice class, and I had half the class write victim impact statements, not for the court, but for a restorative justice process, and half the class write apology letters. Because some of the restorative justice literature says that these processes don't have to happen face-to-face, that sometimes they can happen by letter. And when we looked over all of the letters, there were common themes in all of the letters, that there were the same things that were expressed over and over again. And they're consistent with the literature, they're consistent with everything we talked about today. And this is another sort of a framework, I guess, that the impact of the offense has had on the victim is expressed and acknowledged, that an apology is made, it's sincere, and that it's accepted, that the blame is shifted from anything off of the victim and entirely onto the offender, that forgiveness would be given and that the offender would receive that. These tend to forge a bond between the victim and the offender and bring them both back into being common human beings in the common human race, I guess. That the victim has an opportunity to ask why, and that the offender can explain why the offense was done. And then this is sort of optional, that the victim can believe that something good will come out of it, and the offender says, yes, I'm willing to change, and here's my plan. Here's my plan to make restitution to you, and here's my plan for how this isn't going to happen again. And the victim hears that. And that reconciliation may or may not happen here. But I guess I come from the perspective of thinking that if the apology and forgiveness are both there, that's a good thing, and that's something that people want, and that it's something that we should go for. And that if we just have one, well, that's good, that's halfway there. If we just have the other, that's halfway there. But that together would be the goal, but we're not in charge of making that happen. As lawyers, though, I think that, and there's a whole bunch of ways to look at this. I mean, in criminal cases, you could have these kinds of face-to-face encounters with this core sequence and these things that happen. You could have that as a standalone process, or you could insert it at any level of the adjudicatory process. It could be post-plea, post-adjudication, post-sentence, part of the probation and parole. But as lawyers, or as mediators, I think that we can start to understand this, and we can, not coaching people to give those Machiavellian apologies, those instrumental apologies, but coaching people to say, here's what you need to consider if you're going to apologize. If you're the victim, here's what you need to ask for. Here's what you might consider asking for. Here's what you can ask for. Expanding our mediator skills to facilitate, to give opportunities for this to happen, as opposed to shutting it down. And if we don't want to do that, engaging a social science expert to help us, because we don't know always. We feel like we're over our heads. In the same process in civil, the same kind of process in civil cases. Jens, I also think that in international cases it could work, but I'm an idealist, so there you have that. So some of the things we've already talked about. We talked about a lot of the disadvantages, but I want to bring two to your mind, because a lot of them we've already discussed already. Lawyers tend to not see apology as important as non-lawyers do. There's some empirical research about that. We also see apologies as weakness. We also might have an apology happen and say, oh, now we're really going to move in for the kill. They're admitting weakness in their case. We also are trained, right? We're trained to fight for legal disputes and factual disputes. So if there's an issue of fact, we're going to seize on that, and we're going to say, no, we're not going to let go forward in any kind of apology and forgiveness sequence, because there's a factual issue. We need to hold on to that. Or if there's a legal dispute, we need to hold on to that. We're trained that way. It's part of our personality as well. So for us to let go of some of that and be open to these other ideas is a little bit of a shift. It's a little bit of an obstacle, I think. But I think what's happening in the legal field is that basically people are tired of what we've been doing, and they really want to see, particularly with recidivism, they really want to see some change, particularly the judges. And I think in the legal profession, there's more and more people that are willing to say social science has some information for us that we can use, that we can practice law and we can adjudicate law in a way that's really satisfying for us and really works for our clients, and that our clients say, yeah, that lawyer really helped me. And so with that, I think I'm done. All right.
And our last speaker is Doug, and he's going to talk with us about apology in the medical malpractice setting. Thank you.
No? It was
He's doing. Oh, so I guess
there we
back
go.
down again.
Okay.
Well, I guess I'm going back down.
Super. Hi, I'm Doug Wojcieszak. I'm from the Sorry Works Coalition, and appreciate the opportunity to be here today. Realize I'm the last thing that stands between you and your weekend. So y'all better behave yourself, or it's going to be a long night. I do have the doors locked, so no running out early because of whatever reason. A lot of good comment today. I really appreciate the opportunity to be here. I think one of the things I'm going to talk about was kind of a discussion, following up on what some of the stuff Professor Smith was talking about. We'll talk about and tease out in my 25, 30 minutes here about the differences of empathy versus apology. You're absolutely right. When sometimes attorneys or insurance companies try to manipulate people and just focus on the empathy and just try to get them off cheaply and quickly and early without the big case, without admitting fault, there is manipulation. There are insurance companies doing that. But there's also, from the different perspective, what I'll talk to you about today, when something bad happens, be it in a medical setting or any type of setting, often the immediate aftermath of what happened, we know something wrong happened, we don't know exactly what happened. We don't know if there was fault, if there was not. If there was fault, who was at fault? Who did what? Was it one person? Was there multiple parties? Was it a system error? So what we coach when we talk about, and I'll talk to you about today, I'll emphasize it now and then through my presentation when we do it during Q&A, is it's okay initially, it's the absolutely right thing initially, just simply say, I'm sorry this happened. I'm going to do an investigation. I'll get back to you in a reasonable time. Oh, by the way, is there anything I can do to help you right now through the next day or couple days as far as phone calls, food, lodging, child care, those type of issues. And then if the investigation shows that, by golly, you did make a mistake, well, then you're going to come back with your fault-based apology. I made a mistake. I'm sorry this happened. Let's talk about it and talk about what that means to you. So, and then Susan's comments about the lawyers going in for the kill. I mean, there's some of that going on here too, and we're going to talk about that as well. I think this thing through the disclosure and apology, we're starting to change some of the culture of the law. Defense lawyers are trained to defend at all costs. Personal injury lawyers are trained to go in for the kill at all costs. And I think some of the things that we're finding with the personal injury bar, for example, is ultimately it's the customer, the patient, the family that drives that process. And if they're getting what they want, woe to the plaintiff's attorney. So, well, no, let's go off to court for the next 3 or 4 years and relive the death of your loved one just so I can make a big killing. Or the defense lawyer that's got the doctor saying, yep, I've got to do right by this patient or family. And me and my insurance company already have a program worked out to take care of people that we've hurt with genuine, honest mistakes. It's very hard for defense lawyers to say, well, no, I need to bill for the next 3 years. Okay? Now, before I get into this whole presentation about disclosure and apology, one of the things I do, and I give this talk all across the country, I speak, a lot of my audiences are doctors, are hospitals, are insurance companies, medical associations, med-mal defense, as well as plaintiffs' attorneys. I give a little bit of disclosure on myself and how the coalition came to be and how this whole movement got started. And I'm doing this not just for my own edification and to tell you, things about myself, but to literally plant some flags in the ground for what we're going to be trying to talk about today, albeit in an abbreviated fashion. Okay? My journey into this thing called Sorry Works began in May of 1998. That's when I lost my oldest brother, Jim, to medical errors. He walked into a Cincinnati, Ohio hospital at 2 o'clock in the morning complaining of chest, shoulder, neck, and stomach pain so severe it got him out of bed at 2 in the morning. And you have to understand, Jim was a big, burly, tough guy, kind of guy that got asked to play football in high school. So he shouldered pain extremely well. So for him to show up in an emergency room in a Cincinnati, Ohio hospital at 2 in the morning without mom and dad shoving him there meant something was really wrong. Well, he gets to the emergency room. The doctor said, well, look at you. You're 39 years old. You're built like a brick house. Must be something wrong with your stomach. At that point, my brother said, well, it could be my heart, too. They did do an EKG. They found a murmur on the heart. And my brother said, I've never had any heart issues. And they said, well, look at you. You're 39 years old. You're built like a brick house. Must be something wrong with your stomach. They were developing tunnel vision. They gave him an ulcer cocktail and sent him home. Never drew blood. That's an important thing when you have a heart problem, or you think you do, draw blood. So the next morning, a couple hours later, my parents bring him back to the hospital because by this time he was literally passing out in and out of consciousness. He couldn't maintain consciousness. The oxygen levels in his blood were getting so low, he wasn't there all the time. Well, they get him back in the emergency room. This time they draw the blood, same emergency room. Sure enough, they find the enzyme in the blood showing something is wrong with the heart. They get him into ICU, and this is where the holes, the Swiss cheese, started lining up, as we say, in the patient safety movement in the medical world. The computer monitor over his bed read Ray Wojcieszak. My brother's name was Jim. Who's Ray? That's my dad. Very significant because my dad had had heart stress tests done in this very same hospital in the months prior to my brother's death. My dad at that time had a perfect cardiac workup. No blockage, low cholesterol. In fact, the cardiologist said he had the heart of a 30-year-old man. Yet, a few months down the road, there he was looking at a computer monitor with his name on it, his old son in the bed. Went and got the attending physician. The attending physician was willing to bet his mortgage that no, that was Ray Wojcieszak in that bed. Getting ready to have security, had my dad tossed until he pulled driver's license out to prove his identity. This is a classic case of the charts getting mixed up. Well, eventually they changed the monitor to read Jim, but not before they used my dad's charts to form a diagnosis of a bacterial infection of the heart. For 2 days, they plugged my brother full of antibiotics. He was admitted on a Tuesday. He died on a Thursday. The last afternoon he was alive, they finally figured out they went astray. They ran a probe up his leg to see if they missed something around the heart. Sure enough, they found 4 major arteries blocked. He crashed during the test. They were able to get him to emergency open heart surgery, but they couldn't get him off the table. Basically, the back of his heart was gone by the time they got in there. The surgeon who was brought in at the last minute to literally throw the Hail Mary pass and not been involved in Jim's care up to that point, walked out of the operating room, went to my parents and said to my parents, if the jerks at this hospital had done their job and got your boy to me 2 days ago, and they should have, I could have saved him no problem. I'm sorry he's dead. The damage is too great. That was the last bit of honesty and candor we got out of the Cincinnati hospital. After the funeral, after all the relatives, all the friends went home, my parents went back to the hospital looking for answers. No one would speak to them. Even the surgeon who was so honest that night said, well, look, legal counsel instructed me not to speak to you any further. You have to leave. So we filed a medical malpractice lawsuit. It was a big deal, folks, when the plaintiff's attorneys called my parents' office, or my parents' house. Even for just little things like, what was my brother's birthday, or could we get his tax returns? Or we just had some questions about the type of profession he had. Little things like that were a big deal to my mom and dad because guess what? Somebody cared. Somebody was filling that abandonment that was left open by the medical community. Somebody was taking them seriously. A lawsuit is just another way of saying, hear me now. After a year and a half of litigation, the judge turned to the hospital, the doctors, and all their attorneys said, you're wasting my time. This is not going to come in my courtroom. I don't have time to deal with this. You killed this young man. Anyone can see that. At that point, one of the insurance company representatives who was in on the meeting said, oh, you mean, Your Honor, you think we need to give him give him a couple $1,000? Is that what you have in mind? Literally, the opening offer for a 39-year-old man who was professional, his whole life in front of him, was $1,500. The judge became insulted on our behalf and said, no, you're not paying attention. Go back, figure out what you're going to do with this family. Don't come back. We received a pretty sizable settlement. Can't tell you what that is. All sealed up. Heaven forbid we ever learn from a closed claim in medicine, right? After my parents signed the liability waivers, the attorneys, not the doctors, the attorneys apologized. It was one of those mealy-mouthed, we're sorry this happened, we feel bad for you. No one admitted fault. No one told my parents, especially my dad, the PhD engineer, how the process was going to get fixed so it wouldn't happen again. It drives my parents crazy. My dad especially, the engineer, believes the errors that killed his son are probably injuring and killing other people in that hospital as well as other hospitals. No one learned. My mother agrees over the fact that no one has ever sought them out and just simply said, I'm sorry. No one's been man or woman enough to own up to it. That's my personal story that led to the development of this thing called Sorry Works. I have a professional story as well. It was around the time Jim's case was being litigated. I was a staff person in the Illinois legislature. I worked on the Republican side of the aisle, did legislation, did campaigns, all that stuff. I was offered a job with a group called Illinois Lawsuit Abuse Watch, one of these pro-tort reform groups. You have them here in Ohio. I know because when I started the group, because I got the job with Iowa, I came back out here to Ohio to talk with your people in Columbus about how you do it. Well, when I was interviewing for the job, however, I was very honest with the people who were interviewing me. I said, look, this would happen to my brother Jim. We have filed a medical malpractice lawsuit. Our family is represented by a personal injury plaintiff's attorney. Oh, Mr. Wojcieszak, we believe in legitimate medical malpractice lawsuits. Just the goofy, frivolous lawsuits perpetrated by greedy trial lawyers that delay justice for good people like you. Guess I can do this. November of 99 is when I took the job. December of 99, the first scholarly peer-reviewed paper came out in the medical literature about the potential for disclosure and apology in a medical setting. It was the Annals of Internal Medicine paper written by Steve Kramen and Jenny Ham. And what that paper basically said is that their one VA hospital, when they compared themselves to other similarly situated VA hospitals for size, patient count, bed count, after many years of doing disclosure and apology, at the very minimum, it wasn't hurting their institution financially, but they had a lot of evidence to suggest that it was actually making things better as far as reducing lawsuits and expenses and improving patient satisfaction and patient safety. I went to my bosses in the tort reform movement in the state of Illinois and I said, hey, this makes sense to me. Maybe we need to be telling this to the doctors and the hospitals that paid our bills to talk about tort reform and lawsuit abuse. Douglas, we're never going to tell a doctor he or she's wrong. Son, we didn't hire you to make the doc sorry. Son, we hired you to make the trial lawyer sorry. Well, boss, I told you it happened to my brother. This makes sense to me. Douglas, we're here in Chicago. You go down the street to the AMA or the American Hospital Association or any of these other groups called Chicago Home, but I can't guarantee you have a job when you get back. Okay. So I got back to work. Did that job for a year, then I went back to our legislature. Then I went out and formed my own public relations consulting firm. First client in the door of the Illinois trial lawyers. They knew I knew how to talk about litigation issues and get media coverage. And this is when our whole med-mal crisis was getting going in our state, and the medical community was just, really beating up the trial bar. They want to get their story out. I said, sure. So we talked about disciplining doctors, reforming insurance companies. You've had that fight here in Ohio. You know what that's all about, the back and forth that they do. But in the midst of that work, I got a chance to rediscover Steve Kramen's paper. This time I got a chance to talk to him. We came up with a PR term, Sorry Works, to describe this process. And it just kind of took a life of its own. The trial lawyers who were paying our bills at the time said, hey, this is actually what we're trained to give people in law school. Answers, accountability, and fixes in a fair and swift fashion. Keep going. But the more we kept going, the medical people started calling, saying, hey, this is really interesting. This is fascinating. This might work for us. Where can we learn more about it? So at that point, I knew we were on something special. Because I got to tell you, as a public policy person, a political consultant, what I do mostly for a living, this issue of medical malpractice is the longest-running, nastiest public policy issue in the United States of America, bar none. And there's really no end in it. Even a state like Ohio, where you've got tort reform, you're just one governor one legislature, one set of Supreme Court justices away from not having tort reform anymore. The law can always change. The goalpost can be moving back and forth. But with this thing called Sorry Works, the neat thing is we're reconnecting medical people with the people they're pledged to serve and doing it in a proactive, intelligent way that reduced liability, got a better control over liability, reduced lawsuits and costs, but actually gave people what they wanted, some of the stuff you were talking about, Susan. And the best thing is by disclosing errors and talking about them, we can learn from them so we don't do them again. We increase the safety. So I've been doing this for the better part of the last 3-4 years, wrote a book, and I've got copies here if you want. Let's get into the presentation here, because I know my time is limited. I want to be respectful of your time. I'm going to give you some, I have a couple goals for this presentation. One, blow your mind about medical liability reform, but also get you so excited you go, if you're a doctor or a medical person, we've got some of those folks here today, you go back and start this in your institution, or attorneys, law school people, you tell your friends about this. In that spirit, I'm going to start the talk with some of the disclosure success stories across the country that we're seeing are pretty fantastic. This first story right here is Park Nicollet Hospital up in Minnesota. Patient goes in to get a cancerous kidney removed. They removed the wrong kidney. Horrible mistake. But what wasn't horrible was how they handled it afterwards. The CEO of the hospital, the leadership, the providers that were involved, got with the patient, got with the family. This is an excerpt from a memo that they wrote. But they sat down and talked with them, but after they talked with them, that memo went on their website. We're saddened to tell you that Park Nicollet has made a tragic medical error for which you accept full responsibility. We've apologized to the family. And the rest of the memo goes in detail about what happened, without naming names, and what they were doing to make sure it wouldn't happen again at their hospital or other hospitals. There's no mixing words here. It's all right there. It's a beautiful example of what some of the stuff happening around the country. Here's another one. This one really kind of caught me because I'm the father of a 3-year-old boy. This is a story of a little boy who was just little for his age. Mom and Dad took him to Shands Memorial Hospital, part of the University of Florida system, to get some growth hormone on him, to get some size on him before he went to kindergarten, right? They gave him a crushing, massive overdose of growth hormone. Killed the little boy. Took him off life support after a couple days. However, again, what wasn't sad about the case was how the providers stepped to the plate. Got with Mom and Dad right away. Case was settled for $800,000 to $850,000 pretty quickly. But more important than the money, Mom and Dad are developers. They build things. And in this part of Florida, there is no children's-only hospital, at least when this case broke. And when you put a kid into an adult-centric hospital, as I like to call it, you have the chances for these dosing problems. Remember the Quaid twins? Same deal here. The hospital, the doctors and nurses are involved, are working with Mom and Dad, this little boy, to raise money in his memory to build a children's-only hospital in that part of Florida. What a big wow, huh? Can't get that with tort reform, can you? Here's another similar type of thing. This is Methodist Hospital in Omaha, Nebraska. Young man comes in complaining of aortic dissection. That's a problem with the heart. I'm not a doctor, so don't ask me exactly the anatomy of it or the physiology of it, but it's a big problem with the heart. He had crushing chest pain. He was 19 years old, which is kind of early, but his father, who was 38, had an operation a year prior to get it fixed. They had an uncle die in his early 40s of it. Every time the kid and Mom and Dad went in the emergency room, they said, check him out for this. Oh no, he's too young. Must be something wrong in the stomach. Gee, where have we heard that before? After the third time, went home and died. You can guess what the autopsy showed. Part of the resolution with the family, part of the disclosure, was finding out after they admitted fault and said we're sorry and talked about settlement, was once they got that anger out, and that's the big thing, get the anger out. You can have constructive discussions and figure out what patients and families really want. The family wanted to know this wasn't going to happen again. They wanted to teach other hospitals and other doctors across the country because this apparently happens all too often. So the hospital, as part of the settlement, on their nickel, produced a video with the family about this young man's story. It's on their website, bestcare.org. Bestcare.org. It's right in the middle of the website, and this has been going on 2 years now this happened. And in this video, the chief of staff of the hospital is heard saying, we made a tragic error, but since we've owned it, we've learned from it, we've changed our processes, and guess what? We've saved at least 5 lives of other young people we would have missed prior to this story. Big wow. This is one of my favorite slides when I talk to medical people, when I have more of a medical exclusive audience. This is Beth Israel Deaconess Hospital in Boston. They had a wrong side surgery a year ago. 4th of July, a little less than a year ago. And when they disclosed publicly, and the reporter asked the question, why are you doing this? Isn't this going to destroy your reputation? And this is the response. People want to trust the doctors and hospitals to go to. And I also know that we're not infallible, and by admitting our mistakes and demonstrating our desire to improve, it really helps the people understand we care about them. This is a big deal because one of the big obstacles to disclosure and apology and getting this thing going into medicine, as well as every other type of profession or walk of life out there, is this notion of, people are going to think I'm a klutz. I'm dumb. They're not going to come do business with me. Remember my first slide, Park Nicollet Hospital? I was giving this talk to a group of risk managers. So these are the people that do the risk in the hospitals in northern New England last summer. One of the risk managers said, hey, guess what? My brother was a cancer patient in Park Nicollet Hospital when that whole thing went down. He called me the night all the media stories broke. Hey, sis, have you heard about what happened here? Oh, yeah, are you all right? Sis, I'm in the safest place in the world. These people really care about us. They're on top of the situation. You couldn't take me out of here for $1 million. The public knows mistakes happen, especially in medicine, all the articles and the coverage about it. The question is, are you going to be credible going forward? Now, here's a legal question. Do you need a law? Does there need to be a law in place to protect doctors and hospitals and the insurance companies that cover them so that if they say sorry, so if they do these things I'm talking about, that it doesn't come back to haunt them in court? No. I know Ohio is one of 35 states that have these apology immunity laws. I believe your state is one where it basically covers expressions of empathy or sympathy. There are some states, a few states like Georgia, South Carolina, Colorado, Connecticut, that cover things even so far as I'm sorry I cut the wrong leg off. But do you need a law like this? No. What we try to teach medical providers is we've got to get past that notion in our glove box of our car that says, don't say anything, shut up, call the insurance company. We got to get past the notion of stuff we see on Law and Order and the other cops and robbers shows on TV. And then you say, well, it can be used against you in a court of law, right? Making a mistake does not make one a criminal. But you look like a criminal, you feel like a criminal to a patient or a family when something has gone wrong and you run away and hide. That's the evidence that a trial lawyer looks for. That's what my co-authors, two med mal defense lawyers, call the plus factor. Sometimes medicine is absolutely defensible, but the behavior is indefensible, and cases get settled and money gets paid out when it shouldn't. Consider this quote right here. I was giving a presentation on Sorry Works to the South Carolina Senate shortly after we formed Sorry Works, and I gave a talk like I'm giving to you guys right now. And after I got done talking, the gentleman senators got in a whole debate about do they need to immunize a doctor's apology before he or she says sorry in court. And up to the podium strides President of South Carolina Trial Law Association. Good boy, send us ideas. Gentlemen senators, let me help you out. It's my job as trial law to demonize the doctor, make it look stupid and competent. Boys, you are foolish. If you're telling me the doctor actually tried to do the right thing and help my client, I guarantee you I'm not going to bring out the evidence. Now, learned defense counsel probably going to want to get that evidence. Going to make the old boy doctor look pretty good. I love giving that slide to medical people because a lot of them think it's about the error that gets them killed in court. It's the bad behavior that gets them killed in court. That's the thing. People, I think as Americans, this is one of my little sayings, we can live with mistakes. We're a country of immigrants. We all screwed up somewhere else. That's why we came here, right? Right? You look at Ellis Island, those are not successful people getting off the boats, They are people that, didn't get it right, so they're coming here for their second, third, or fourth chance, right? But we don't get cover-ups. We don't tolerate them. So that's kind of what we're talking about. I'll be lecturing from the book here today. Very quickly, obviously my time is running short. I'm going to give you a few more success stories, talk about how this is a program, what disclosure means for the stakeholders, and then tips on how to get a program going in a hospital or any other type of setting for that matter. There's a lot of success stories out there. They're in the book. I'll give just a very couple quick examples. University of Michigan Hospital System. I know I'm in Ohio. This is the Buckeye State, right? The neighbors to the north, that place up north, Ann Arbor. They have cut their lawsuits in half. They reduced what they spent on defense counsel by over 2/3. They have their own insurance company. They've reduced their reserves, what they're holding back against future claims, from $72 million to less than $20 million today. University of Illinois Medical Center in Chicago. It doesn't get much tougher for a litigation venue. 4 disclosures first year doing it, only one claim. And the list goes on and on. And even New Jersey, a state without tort reform, some hospitals out there a couple weeks ago said they've cut their lawsuits in half. Can this work with, insurers and independent? I mean, a lot of the stories I gave you were with hospitals. Can it work with independent doctors who have a medical practice out in the suburbs of Cleveland, or an insurance company that covers? Absolutely, absolutely. And we did work recently in Oklahoma with a doctor-owned insurance company. We are in the process of training all their doctors. We trained all their lawyers a couple weeks ago. Now we're training all the doctors. This can work in any setting. There's lots of excuses you can hear about, well, this can't work, or it's too difficult here. Baloney. Because the one commonality between every hospital, every doctor, every medical setting is the patient or family. It doesn't matter if we're going to a VA facility, a university facility, a private facility, or going to our doctor's office down the road. Patients and families have all the same hopes and expectations and fears. And when something doesn't go right, we need to be treated with dignity and respect and restore that trust. Short of that, we're going to have problems. So how does this work? It's got to be a program. It's a program and a process. The ultimate thing that needs to happen in any type of institution, medical or non-medical, is the leadership needs to buy into it and get training for the people that are involved. And ultimately what we recommend is a 3-step disclosure process. First step is all about empathy. I am so sorry this happened. Look, your mom was supposed to be going home with you in a couple of days. You got that big birthday party next week and all the grandkids are coming over. But she's in ICU now. I'm so sorry this happened. We're going to do an investigation and figure out what happened. We'll probably get some answers to you Monday morning. In the meanwhile, is there anything we can do for you? Do you need food, lodging? Do you need a minister? Again, I'm so sorry this happened. Again, I just empathized. I didn't, and I'm not trying to manipulate. I'm just simply saying what I know, because even at 99.9% of adverse events, you don't know. What about a wrong side surgery, Doug, where even the patient can see that something is wrong and the family can see? Look, I'm sorry we made a mistake. We're supposed to operate on mom's left knee. We operate on the right knee. I'm going to get back to you in a couple of days after I have a chance to figure out how exactly this happened. Because even in those slam dunk cases, there's usually a lot of who, what, where, why, and how to figure out. Nothing wrong with going in and saying, I'm sorry, and we'll get back to you in a reasonable period of time. That's all step one is about. It's about empathy. It's about reconnecting with the patient or family, because one of the biggest themes, there's a lot of themes that you hear when you talk to defense counsel and plaintiff's counsel, and I talk to them all the time. Med-mal depositions. No one said they were sorry. Providers didn't act like they give a damn. I felt abandoned. They didn't take me seriously. I had no idea what was going on. These people just dropped me like a bad habit. You listen to my words there. I never gave, during that role play with myself, my hypothetical patient a chance to feel that way. I told him we're going to get back to him on Monday. We're doing an investigation. I'm sorry this happened. Feel bad for you. Can I take care of any little problems for you now? Oh, what's that? You got kids over at daycare? And they need to be picked up in a half hour? I'll send the hospital van over there right away. Your children will be here in an hour. Oh, you want them to take them to your mother's house? No problem. We'll get them there. Those little things are mere pennies, mere pittance to a large institution, but to a family struggling through something like this, it means all the world. Step two, the investigation. We tell hospitals and doctors and medical people, insurance people, move as fast as you can. Involve outside experts so it doesn't look like you're grading your own papers. And step three is the resolution. And it's basically going to come down to one of two things. Either, I'm sorry we made a mistake, and let us explain to you why and how do we take care of this for you? Or, I'm sorry this happened again, but we did the investigation. We got the best experts in the world. We got the guys from Harvard, Yale, and Stanford. And no mistake happened. Let us show you how. And, in this slide right here, what we recommend is having a meeting, a face-to-face meeting, and 4 things happening in that meeting. The apology, the admission of fault, the explanation of what happened, and the discussion of unfair compensation. And also, so people don't think they're being manipulated, tell them they have a right to bring legal counsel if they so want. Plaintiffs' counsel get this. Furthermore, the programs that do this really well, like University of Michigan, one of the first things they did when they set the program up is they went out and talked to the plaintiffs' counsel. They said, here's what we're doing. We want to work with you. We're not going to call you sharks in suits anymore, guys and gals. We're going to treat you with respect, and we want to work with you collaboratively when things go wrong to figure out what happened. And that means when someone shows up in your office and says they want to sue the U of M, give us a call. Send us an email. We'll sit down and talk with you. If we made a mistake, we'll take care of them. But if we didn't, we're going to prove it to you. We want you to go away at that point. The New York Times did a fantastic article about disclosure last May 2008. It's on our website, sorryworks.net. It's under breaking news. You have to scroll down a little bit. May 2008, sorryworks.net, where they interviewed plaintiffs' counsel in Michigan, as well in Chicago around the UI's program. The quotes, you can't believe the quotes. One of the best quotes was the last quote from a very prominent personal injury lawyer in Michigan, where he said, when it comes to the U of M, a lawsuit truly is the last recourse. And if we sue them, we know we got a long ride because they believe they're on firm ground, and guess what? They usually are. Because the cases where they're not on firm ground, we took care of those a long time ago. I know a lot of medical people get very concerned about when you talk about the compensation thing. Well, why do we got to pay? What's this going to cost? Well, they get concerned about it because for so long, that's all they've been concerned about. They've made this a self-fulfilling prophecy. They've taken the apology, the admission of fault, the explanation away. Well, guess what? If that's all the family's got to talk about, then I'm really pissed. And doctor, I'm going to own this hospital. But the programs who've been successful, what they've learned is that when they change the discussion from I'm going to own this hospital to what's fair for me, the cases get taken care of for a lot less. And not just in the settlement costs, but the litigation expenses. And it's not the type of where we're going to buy them off cheap. These are reasonable settlements where you just don't have 3 years of litigation costs built into it. These are reasonable, fair settlements. And you've got attorneys usually on their side taking care of the family. If there was no error, again, you're still going to meet with that patient, that family, that attorney, empathize, answer questions. What happens over time is we get what we call the honesty dividend. When a hospital says they didn't make a mistake, when a doctor says they didn't make a mistake, when an insurance company representing those people says a mistake didn't happen, guess what? They get believed. Because one of the biggest bugaboos in medical malpractice, in most forms of litigation, but in medical malpractice especially, doctors win 80 to 90% of the cases go to court. And as our former president would say, that's a lot of frivolous litigation. You know? It's not frivolous, Mr. President. You look at medical malpractice cases, even the one that are losers, you read both sides of the story, they both seem pretty credible, don't they? Most oftentimes than not, they do. The problem is the public just really likes doctors. They really do. So they're more inclined to believe them. The problem is doing 40 to 50 to 60 years to deny and defend has made doctors not very believable when they look across the table to a patient or family and say, we didn't make a mistake. But when you do this program, you get believed. You rebuild that credibility. It's very important. Again, it's a 3-step disclosure process: empathy, investigation, resolution. 3 main principles: compensate quickly and fairly in inappropriate care causes injury, defend medically appropriate care vigorously, and reduce patient injuries by learning from mistakes. Number 2, this is not a no-fault deal. You know, we believe if we're going to tell doctors or any type of professional or any type of person from whatever walk of life, if you're going to say sorry and when you made a mistake, you know, take care of people, when a mistake did not happen, you know, nothing gets paid out. You empathize, you take care of people, you help them out, but you don't pay. Remember who I represent. I'm the patient-family perspective. I don't think a doctor should pay a nickel if a mistake didn't happen. I don't believe in that. Stakeholders. How do the stakeholders view this? You know, a lot of people say the defense lawyers will never go for this. Well, my 2 co-authors are defense lawyers. The defense lawyers we work with, and we're hearing this more and more from defense counsel, is they get involved earlier in the cases. They get a chance to create good evidence for a strong defense if litigation moves forward. One of the biggest things and one of the biggest frustrations for defense counsel in this type of cases is they don't hear about stuff for 6, 12 months, even longer after the event happened. And by that time, well, everyone's good and mad at each other. The family's already been in the plaintiff's counsel's office. They dropped a book on the plaintiff's attorney's office about everything that happened from Dad from the moment he walked in the hospital to the funeral home to a week after when that form sympathy card came from the CEO of the hospital. It was addressed wrong. All that stuff shows in the plaintiff's attorney's office, and the defense counsel is like, well, how do I defend this? How can I get in there and work with these people? The doctor doesn't know what's going on. It eliminates those frustration points, and ultimately it becomes a more well-rounded relationship. Because one of the biggest things, I remember when I wrote this book, my dad said, you're right, defense lawyers, how are they going to make money off this, Doug? They can't be for this. Well, yeah, they can, because there's more than one way to make a living as a defense lawyer. Yeah, you can defend the case for 5 years and charge $250,000. Or you can look at all those clients you have a relationship with and say, look, I can do more for you than just take you to court. I know about what you're doing wrong. I can help you improve your processes. We can do about risk management. We can do consulting. We can keep you out of court. We can keep you from making a mistake in the first place. Because I know a lot about you. So it becomes a more well-rounded and as well, good relationship. Providers, immediate and permanent control of liability issues. Bye-bye politics. When I talk to doctors, they find that very refreshing. Oh, I don't have to go run to the state capitol anymore? I don't have to worry about who's being elected to the Supreme Court? No, this is customer service. It can never be taken away. So much of what I'm talking about with medical malpractice and litigation in general usually revolves around service and communication issues. I tell docs to focus on that, forget about the law and the politics, the politicians, the media, and focus on service and communication issues, because that's what me, the patient, me, the family wants. Better closure, better healing. Sometimes doctors and nurses suffer more than the patients or families. And tort reform can't cleanse their soul. They need to look someone in the eye and say, I'm sorry. And even if they don't get forgiveness, even if that family can't get past the hurt, at least unloading that can be very therapeutic and very good. And the patients and families come back. Even in times when there's been a serious error or even a death, if the institution has the character to stand up, they will come back for future care. Patients and families, they get what we really need. Answers, accountability, fixes. That's all we want. It's not, yes, if you kill a breadwinner of a family, we're going to need money. We're going to need that. We got mortgages to pay, we got kids to feed, go to college. We're going to need money. But do we need a lottery ticket? No. Talk to us. Get the anger out. When you get the anger out, you get the anger out by being accountable to us. When you get that anger out, you can figure out what we really need. Yes, you crippled my mom. She's going to come live with me now. We need to do some things in my house so she has a reasonable standard of living. And so me, my wife, and kids, we also have a reasonable standard of living. She doesn't drive us crazy. Can you help me? Sure. Big thing is we want to know our suffering is not in vain. Medicine is going to improve. And the big thing is, one of the things that's kind of turn your head on, makes litigation so not good sometimes, is when the monetary help is needed the most. In the days, weeks, and months after that adverse event, it ain't there. Most med mal litigation takes 3+ years. With this process, you're talking weeks or months. Much better. Hospitals and insurers, litigation goes down. Less jousting, less finger pointing between providers, and improved quality and safety. Personal injury lawyers. Again, I talked about this with the folks in Michigan. Treat with respect, working relationship. Legitimate cases settle quickly and fairly, and they get the payday right now. Non-cases or non-legitimate cases drop before a significant investment. And again, there's that New York Times article. I really encourage you to read that article. Where do people go from here? Again, we always preach a program. I once had an insurance company professional in California say to me with a straight face, "Oh, we'll just let the docs do this ad hoc." "Oh, you will? It won't work then." And she got all offended. I don't really care. It needs to be a program. It starts with a few committed people, training and resources like our book and other stuff, our website. Form a committee, start small, publicize successes, and then work hard to keep the culture alive. I know I blew through this stuff. This is like an hour talk, 25 minutes. There's my contact information. We got copies of the book afterwards, just $20. Be happy to go to question and answer. Thank you very much for your time and attention.
We have time for questions for all our panelists. And I think one of the things that strikes me is that what we've been talking about this afternoon is creating structures and support for people to do the things they ought to be doing anyways, just behaving well.
Very good job.
Thank you.
I'm a retired OBGYN, 50 years in practice, managed to stay on court. I love my profession. We work our tails off.
You bet.
I've been around a lot of my friends who suffer badly. As you say, sometimes the nurses and doctors suffer more than the families. The thing that happens when something goes wrong, or even if it's a relatively minor thing and you're not sure if anything's going to come to it, first thing you do is you let your malpractice people know about it. What's the first thing they tell you? Don't say a word and don't write anything on the chart. And now these are people that we've paid thousands and thousands of dollars to take care of us.
Hundreds of thousands.
They protect us from the frivolous suits, of which there are more than legitimate ones. I will tell you that if my lawyer, if I don't do what he says, now here again, I've been very fortunate not to be in this situation. But if I go to this family and say, this might bother you a little bit for a while, I'm sorry, blah, 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 what have you. And then my lawyer says, look, I told you, keep your mouth shut. So
Sure.
A lot of people should get 25, 30 grand right up front because a relatively minor thing.
Yeah.
It drives me crazy. People in Denver, Colorado are doing some good stuff on this. So I've been working my tail on healthcare reform since I retired.
Sure.
And I want to hear a lot more about this, but you got to tell me how to fix it so that my doctor friends can do what you asked. Right now, we can't.
Well, I think the thing is that you do need to retake control of your practices. It starts. Okay, well, you're paying thousands and thousands of dollars to an insurance company. You know, the first thing I would do when you get out of here today, or it's Good Friday, probably maybe Monday, pick up the phone, call your insurance company. Say, I've heard about Sorry Works. Okay, well, let me just finish. What ultimately needs to happen, like I said, we have trained, or we're in the process of training a good chunk of the doctors in Oklahoma who are in a similar situation as far as you are, where they have a med mal insurance company with lawyers and all that stuff. We did the training for all the lawyers, and a lot of the lawyers told us, this is a breath of fresh air. I mean, that whole notion that lawyers don't want you to talk to patients and families is kind of old school and bad school. Very bad school. A lot of lawyers will tell you today, nothing wrong with going in there and saying, hey, I'm sorry this happened, and doing those empathetic things I talked about. The charting question, again, what you talked about, old school, bad school. One of the things I hear from a lot of defense lawyers today, what drives them crazy is that nothing is written down. If nothing's written down, it didn't happen. But guess what? The patient and family, they got everything written down. They got a great story to tell the plaintiff's attorney, and you got chicken scratch, if that, in the chart. So if I had a longer time to talk here, we would have talked about informed consent. It starts in informed consent and all the way through the process. So I think what I'm really hearing from you, and it's a legitimate anger, is as a provider you feel put out by the lawyers and the insurance companies for years who have given you that type of advice. How do you turn that culture around? It starts with you and your colleagues saying, you know what, this is good for us. It's good for the defense lawyers, good for the insurance companies, good for the hospitals. We need to get training. Literally, we spent days in Oklahoma over the last 2 months giving expanded talks on this, doing all the Q&A, getting the docs and the lawyers in the same room where they're all like, oh, you like that? Yeah. You like it? Oh, okay, let's do this. That's what, you got to break down those barriers.
Okay, I will tell you that a few years ago, I got a biomedical ethics master's here at Case Western Reserve because I don't like what's happening to my profession. I sit on an ethics committee where I can volunteer my time. I'm not allowed to do it because I still have a tail for all those thousands of babies I delivered.
Right, till 18 years
I'm not
old.
allowed to do anything, even volunteer. Now, they did let me go into Mexico at a little clinic.
Yeah.
But I can't do stuff that I'm capable of doing that I would do for free.
Right.
Because I've still got about 7 or 8 more years until my babies hit 18 or 21, whatever it is.
20,
and
yeah.
I'm off the hook.
Right. Yeah. Excellent questions. It ultimately comes down to, we tell us providers all the time, you've got to retake. And I get brought into a lot of institutions just to give a talk like this. I'll talk for an hour and a half. And you'd be surprised. It's like setting off a bomb in a good way. The doc's like, yeah, we want this. The lawyer's like, oh, this is okay. Let's talk with the docs and figure out how to make this happen. And so it works.
Just to be the other side, I'm a plaintiff's medical malpractice lawyer, and I specialize in obstetric malpractice. You two, there is a huge problem, and we have got to all work together. When I have parents that have an infant that come to me, they have a lot of concerns. But you've nailed a couple of them. The first is, what happened?
Yep.
The second is, are they doing this to any other babies?
Yep.
When we try to do an investigation, one of the things that we want to know is this a pattern of conduct that is so protected, we can't find that out.
Right.
The Federal Data Bank, the Ohio State Medical Board, any reportings of settlements in the past, credentialing files, these are
a big secret.
Huge, we can't find it out. Also, the medical literature is being infiltrated with protective, defensive literature that's not helping solve the problem. So I think that we have all got to start talking to each other, and we've all got to work together, because what I'm seeing is the same kind of injuries, the same kind of mistakes.
Again, and again.
And it's sad. It's just really, really sad. But
right.
that's I guess what my issue is are you looking to form organizations, or when you go to a hospital or you go to a professional organization, are you getting all of us on panels to work together? And also, are you also, in Ohio, we have this peer review statute where all of the investigation, credentialing files and everything, that's protected. The Federal Practitioners Data Bank, where all of the settlements get reported, we don't have any access to. Is that ever going to change? Because that's part of the problem too.
Excellent questions. And you're right. And you know, I have a saying, and sometimes doctors wince when I say it. You know, they believe secrecy is necessary for them to have robust discussions, but it's kind of like antifreeze to a puppy dog. It tastes great going down, but it's really a killer. Because secrecy, you know, when you tell a patient or family, well, nothing bad happened, can't show you that though because it's all sealed up. Like, give me a break.
And I've been listening to this all day long, and I keep thinking if my clients could come to something like this and understand about reconciliation and forgiveness and moving on. I mean, that's, for a lot of plaintiffs, it is truly not about the money.
It's about, and the thing that's interesting is the institutions that do this, they find ways, sometimes creative ways, to sidestep all the stuff you talked about with the peer review protection, all those legal things that the medical groups have lobbied for years. Because at the end of the day, you know, the investigation they do, it's their friend. It's a friend to everybody. Because if you made a mistake and you're going to go into the patient or family and say, we made a mistake, we did you wrong, we're sorry, here's how we're going to fix it, offering all that up to them as evidence shows that you're playing fair and you're not holding anything back. However, if you didn't make a mistake, giving that to the patient or family, saying, here it all is, here's our expert reviews, go get your own expert to look at it, you know, that backs them up as well. It's all evidence.
And just one real fast question.
Sure.
Are you, and what you do, are you building into the system that physicians or care providers who are repeat problem issue people, I
Right.
don't want to be disparaging,
Sure, I understand.
that the institution is doing something about that internally?
Yeah, the thing that's interesting is when an institution, when I say institution, I mean a hospital, a large medical practice, an insurance company with a pool of insureds, when they adopt this type of program, you know, the thing that's interesting is that they become much more rigorous in their discussions about quality and safety. You know, like the University of Michigan, they saw their reports go through the roof on, you know, the reporting, you know, went way up, even on the minor little issues. And they're having much more robust discussions about quality and safety. And exactly to your question, where they've got providers who just aren't cutting it anymore. You know, move them on to something else. Get them, you know, it's just not their time anymore. Absolutely. That's the beauty of what this is all about.
I guess this question is primarily for Doug, but perhaps the other panelists will have an opinion on this too. It's a related two-part question, and I'm sort of building on what you were commenting on before. In part, what concerns me is the sort of the present incentive structures in law, especially with contingency fee arrangements. And I have a saying that, you know, few attorneys want 1/3 of your apology. Because it's not clear, sort of. I mean, there's some truth. Sort of this, the way that it is historically structured, all the incentives are sort of away from apologies, and there's that worry. When you put up that slide of the statement from Park Nicollet Hospital,
Yes.
you mentioned that there were no names, right, of who exactly did what, and to me that was a big red flag, which spoke exactly to the issues that you were worried about, because there are probably people in that hospital who are repeat offenders. I was involved with a case at Mass General Hospital where you know, someone died from an emergency procedure, sort of clear medical error, and it turned out that this doctor was on probation for chemical abuse, substance abuse, and that there were sort of a series of things, and this was the one that ultimately got him fired, and he had sort of done all sorts of things wrong before that. And when I see a collective institution like a hospital sort of saying something that in a lot of ways looks nice and looks much better and is a step in the right direction, when they're not naming names and attributing blame, whether it's blame in terms of this individual doctor did this wrong here, or we have this policy that tends to result in these kinds of injuries, right? Not parsing the nature of the injury enough, I worry whether the reform is ever going to be effectuated, right? Because, for example, if I'm a patient in that community, I want to know which doctor operated on the wrong side. And I want someone to be held responsible, and it's nice for the hospital to say that we take responsibility.
Sure.
But if they don't sanction or punish or get rid of that doctor or find, and I want to know that there measures have been taken to correct that, I don't know that those measures have been taken until I get a more exacting account of precisely what happened.
Well, let me stop you in the interest of time. To your question, it's a wrong side surgery. They talked about how the slides got the memo is on our website, sorryworks.net. You can read it and draw better conclusions than just an excerpt of it. They talked about how the slides got mixed up. So is that entirely the doctor's fault, or maybe did the nurse get things mixed up? When you say you want to call the doctor out on Main Street, you've got to be careful about that. Remember, I'm coming from the patient-family perspective. Also, if there is an overabundance of public disclosure, guess what? You will drive mistakes deeper and deeper. People won't want to talk about them at all. So there's got to be some parsing out of that. And I understand your concerns about quality, and the public has a right to know. And I don't have all the answers for you. I'm just simply pushing back on you a little bit, saying we need to think about these things and move forward. But I can promise you that when hospitals do these type of things, internally their culture changes, and they have much more robust discussions, where maybe even if Dr. X is not on the front page of the Sunday paper, folks in that organization know and steps are taken, because when a mistake like that happens, the entire ship goes down. To your question about lawyers and contingency fees, again, that's a question we always get. How do plaintiffs' lawyers look at this? How do defense lawyers look at this? We hear stories, again, this is where the relationship is really getting going, like around Michigan or down in Lexington by the Lexington, Kentucky Veterans Administration Hospital, where sometimes lawyers come in because there's, if the hospital's sitting there saying, I'm sorry, I made a mistake, let's take care of this family, there's no case to be litigated there. They sometimes come in on a consulting basis, where they're coming in on an hourly fee. They're charging $200, $300, $400 an hour to work with the family, get the paperwork filled out, make sure it's a fair deal, and to be that impartial advocate for the family. So there's lots of ways this can be worked out. And if a lawyer gets a third of it, a lot of docs are like, well, I need to know how much the lawyers make. I'm like, Doc, that's none of your business. That's a private contractual relationship between a patient, family, and their attorney. You need not to worry about that, doctor. So what? He drives a nice car. You drive a nice car too. Get over it. Other questions?
Just a slightly different perspective on this. I was in-house environmental counsel for a big oil company, and we spent a lot of time talking to, it's not medical context, but talking to the people in charge of things like when the oil gets out of the pipe that's not where it's supposed to be. And trying to drive home the same message that you have talked about, which is that somebody is going to tell the story. It might as well be yours. So talk about it. Tell people what it is they need to hear, and where people actually implemented that, situations that could have been a huge disaster turned out not to be such a big deal if you go in and you take care of what needs taken care of and actually answer questions and talk to people.
Well, it's like the old Tylenol deal. When they got the poisoning of Tylenol, that company wouldn't be around anymore if they did deny and defend.
Right.
But they came forward, did the right thing, and the public gave them another chance. You're absolutely right. This has got to
They don't always listen to you, but
yeah.
And I would think that any any large corporate, this isn't just limited to medical malpractice,
Absolutely.
like you said. Why not expand this to almost all clients, almost all corporate? I was corporate counsel, absolutely.
Yeah.
It's a paradigm that works. I'm so glad that it's working
Yeah, thank you.
for us to.
Other questions?
Several of you have mentioned that it really matters from the patient's perspective to be told the truth. I find that fascinating as deeply true. I think it's also an analog in the case of forgiveness, where part of what one wants is an account from the offender as to why they did that and an explanation that makes them intelligible. Mm-hmm. And I was just wondering whether any of you has a view about why we feel that it's so important to be told the truth of the matter, and putting aside the question of the wrong being done to other people.
Because I think it's true in anything, but especially in medical malpractice. Why is medical malpractice one of the nastiest areas of litigation? Period. Why is it so politicized? Because ultimately, you're talking about my loved one or my life. There is no service relationship in the United States of America or even the world where so much trust is transferred from one party to another. And when something goes wrong and that situation is met head on with silence, with stonewalling, with get out of my hospital, I mean, people go bananas, and rightfully so. But when you do a 180 and give people the truth and give them what they need, they can move on. You know, we're all going to die one day. We all know that. That's how the game's played. So the truth, you know, that's all you got when the day is over.
And in the family law context, and Carrie Menkel-Meadow has done some of this work, what they have found is that in very close relationships, for example, marital relationships, it's incredibly important for a person who has been betrayed to start healing, whether the relationship can continue or not. It's very important to have the other person acknowledge that I've done something wrong, and it is what it is. So, for example, a husband who says to his wife, I'm in love with someone else and I want out of the marriage, I'm sorry, but I have fallen in love with someone else. That honesty is very important for the other spouse to actually be able to start healing. So it's not really an apology in the sense that he's not really sorry he's in love with someone else, no. but it's honesty and allows the person to move on.
I wanted to talk a little bit about, like, there's a shift that occurs, and I was thinking of a particular mediation. I had an opportunity to mediate. It was this one person had stolen something from these other group of people, and there was an apology. There was sort of an apology, and there was sort of a, I did this, and but there really wasn't any resolution, and you could see from the body language that this person just something wasn't hitting right, and so finally we turned to the people, the victims, and said, well, are you ready to accept, this person's resolution of the problem? And they said, no, we really feel like something's missing. And it wasn't until the offender, broke down, started crying, and said, this is why I really did what I did. Let me tell you, I stole from you because I'm jealous of you. And because I think you're better than me, and that's why I took from you, and it made perfect sense. And when that made sense, and you could see emotionally it thunked, then resolution came within minutes. It was like, oh, well, that, it was like everybody kind of sat, and then the resolution was right there.
So maybe the common thread here is really respect.
Yes.
It's
respect. The honesty or the acknowledgement is a way of showing that you are respected, and that's why we value it so highly.
Yep.
There's something about the restorative justice talks about restoring dignity and respect and prestige and value and worth to both the victim and the offender. It talks about restoring, it makes you think about, wow, those things have been taken away by what's happened. There's been a wound. And so, yeah, it seems like that's the case.
Well, maybe that's a good note to end on.
Thank you very much.
Thank you.
Let me say before you get up, just in conclusion, thank you very much for coming. And I want to thank all of our speakers really for this wonderful excursion into the theory and practice of forgiveness, reconciliation, and the law. And we're going to hope to put this into printed form and have it for posterity as well. Thank you very much for coming.